I never thought a Tuesday morning in Scottsdale, Arizona would turn into a legal battle that would consume the next 6 months of my life. But there I was, staring at an empty spot in my driveway where my perfectly street-legal golf cart had been just an hour before. My name is Quentin Townsend, and I had moved into the Saguaro Springs community about 8 months prior. The neighborhood was one of those planned developments where every house looked like it belonged in a catalog, with manicured lawns, pristine sidewalks, and enough rules to make a military academy look relaxed. I had read through the HOA documents before purchasing my 3-bedroom ranch-style home, and while some regulations seemed excessive, nothing had prepared me for what was about to unfold. The golf cart in question was a 2024 club car Onward, fully equipped with headlights, taillights, turn signals, brake lights, mirrors, seat belts, and a vehicle identification number. I had registered it with the Arizona Department of Transportation, paid for proper insurance, and received official license plates. According to Arizona law, my golf cart was classified as a neighborhood electric vehicle, which meant it was legally permitted to operate on roads with speed limits of 35 miles per hour or less. My entire neighborhood fell within that category, and I used the cart for everything from grocery runs to visiting friends a few streets over. That morning, I had parked it in my driveway after returning from the local coffee shop. The cart was positioned neatly behind my truck, not blocking any sidewalks or extending into the street. I went inside to work from my home office, answering emails and participating in video conferences for my job as a software consultant. Around 11 o'clock, I heard a diesel engine rumbling outside and thought nothing of it until I glanced out the window and saw a tow truck backing into my driveway. I rushed outside, still wearing my house slippers and clutching my phone. A man in a dirty yellow shirt was already hooking up my golf cart to his truck's lift mechanism. "Hey, what are you doing?" I shouted, jogging down my front steps. The driver barely looked at me. "Got a work order to tow this vehicle. HOA request." "You cannot just tow my golf cart from my own driveway," I said, my heart racing. "It is legally parked on my private property." He pulled out a crumpled piece of paper from his pocket. "Says here the HOA authorized this tow. You got a problem, take it up with them. I am just doing my job." "Let me see that," I demanded, reaching for the paper. The work order had been issued by someone named Brenda Carmichael, who apparently served as the HOA president. The reason listed was unauthorized vehicle storage in violation of community covenants. "This is insane," I muttered. "That golf cart is street legal. I have registration and everything." The tow truck driver shrugged. "Not my concern, buddy. Take it up with your HOA. You want your cart back. The impound lot is on East McDowell Road. Fees start at $200 plus $50 per day storage." I felt my blood pressure rising as I watched him secure my golf cart and drive away. This had to be some kind of mistake. I immediately pulled out my phone and called the HOA management office. After navigating through an automated menu system that seemed designed to frustrate callers, I finally reached a live person. "Saguaro Springs HOA, this is Jennifer speaking. How may I help you?" "Yes. My name is Quentin Townsend. I live at 4782 Desert Bloom Drive, and someone just towed my golf cart from my driveway. I need an explanation right now." There was a pause, then the sound of typing. "Oh yes, Mr. Townsend, I see the note here. Your vehicle was in violation of Section 7.4 of the Community Covenants. No recreational vehicles, boats, or off-road vehicles are permitted to be stored in visible locations, including driveways." "But it is not an off-road vehicle," I said, trying to keep my voice level. It is a registered street-legal neighborhood electric vehicle. I have license plates from the state of Arizona. I understand your frustration, Mr. Townsend, but the HOA board has determined that golf carts fall under the category of recreational vehicles. You will need to submit a formal appeal if you wish to contest this decision. Who made this determination? I want to speak with whoever authorized this tow. That would be our president, Brenda Carmichael. She is not available right now, but I can schedule you for the next board meeting. That will be in 3 weeks. 3 weeks. You expect me to wait 3 weeks while my legally owned, legally registered vehicle sits in an impound lot racking up fees? This is ridiculous. Jennifer's tone remained frustratingly neutral. I apologize for the inconvenience, Mr. Townsend. Those are our procedures. I can email you the appeal form if you would like. I hung up, resisting the urge to throw my phone across the lawn. This was clearly some power-hungry HOA board member on a crusade, and I had become collateral damage. I went back inside and immediately started researching. I pulled up the community covenants and read through section 7.4 word by word. The language was vague, referring to recreational vehicles without providing a clear definition. Nowhere did it specifically mention golf carts or neighborhood electric vehicles. Next, I researched Arizona law. According to Arizona Revised Statutes Section 28101, a neighborhood electric vehicle was defined as a vehicle that met specific safety standards and was legally entitled to use public roadways within certain limitations. It was not classified as a recreational vehicle. In fact, the state made a clear distinction between recreational off-highway vehicles and street-legal electric vehicles. I had a case, a strong one. But I also knew that dealing with HOA bureaucracy could be like wrestling with quicksand. The more you struggled, the deeper you sank. I decided to retrieve my golf cart from the impound lot first, then figure out my next move. The lot was a dusty, chain-link fenced compound filled with cars in various states of distress. I paid the $200 fee with my credit card, gritting my teeth as I signed the receipt. The attendant, a bored-looking woman with purple-streaked hair, barely glanced at me as she processed the transaction. Driving my golf cart back home, I received several friendly waves from neighbors. Many people in Saguaro Springs owned golf carts. It was one of the community's selling points, actually. The developer had advertised it as a golf cart-friendly neighborhood with easy access to local shops and restaurants. I had seen at least a dozen other carts parked in driveways throughout the community. Why had mine been singled out? I parked the cart in my garage this time, not willing to risk another towing. Then I spent the rest of the afternoon documenting everything. I took photos of my registration, license plates, and insurance documents. I photographed other golf carts parked in visible locations throughout the neighborhood. I printed out relevant sections of Arizona law regarding neighborhood electric vehicles. I was building a file, and it was getting thick. The next morning, I received a letter in my mailbox. It was from the HOA, printed on official letterhead with the Saguaro Springs logo featuring a cartoon cactus. Dear Mr. Townsend, this letter serves as formal notice that you are in violation of Community Covenants Section 7.4 regarding unauthorized vehicle storage. Your golf cart was observed parked in your driveway on May 14, 2025. As per our enforcement procedures, the vehicle was removed at your expense. Any future violations will result in additional fines of $100 per occurrence. The HOA board takes community standards seriously and expects all residents to comply with established rules. Should you wish to appeal this determination, you may submit a written request to appear before the board at our monthly meeting. Sincerely, Brenda Carmichael, HOA President. The date bothered me. It was now May 15th, which meant Brenda had acted incredibly quickly. Most HOAs gave warnings before taking enforcement action, especially for first-time violations. This felt personal, though I could not understand why. I had never even met Brenda Carmichael. I drafted a detailed appeal letter that same day, explaining the legal distinction between recreational vehicles and street-legal neighborhood electric vehicles. I cited specific Arizona statutes and included copies of my registration and insurance. I requested an immediate hearing and demanded reimbursement for the $200 towing fee. I hand-delivered the letter to the HOA management office, getting a time-stamped receipt from Jennifer at the front desk. The board meets on the first Tuesday of each month, she informed me. That would be June 3rd. You will receive notice about whether your appeal has been added to the agenda. Whether this is a formal appeal, do I not have a right to be heard? Jennifer gave me a sympathetic look. The board has discretion over agenda items. But I am sure they will accommodate you, Mr. Townsend. I left feeling unsatisfied but determined. I had 3 weeks to prepare, and I intended to use every minute. During those 3 weeks, I did more research than I had done for my college thesis. I discovered that HOAs in Arizona were governed by specific statutes, primarily Arizona Revised Statutes, Title 33, Chapter 16. These laws outlined homeowner rights, board responsibilities, and enforcement procedures. I learned that HOAs could not enforce rules that violated state or federal law, and they were required to follow their own procedures as outlined in their governing documents. I also joined several online forums for HOA disputes and discovered I was far from alone. Thousands of homeowners across the country dealt with overreaching HOA boards, petty enforcement actions, and selective rule application. Some stories made my situation look mild by comparison. Still, the common thread was clear. HOA boards sometimes attracted individuals who enjoyed wielding small amounts of power over their neighbors. I reached out to a lawyer, a guy named Marcus Patel who specialized in HOA disputes. His office was in downtown Scottsdale, in a modern building with floor-to-ceiling windows overlooking the McDowell Mountains. So they towed your street-legal vehicle from your own driveway, Marcus said, leaning back in his leather chair. He was in his mid-40s, with graying temples and sharp eyes that suggested he had seen every variety of HOA absurdity. And you have full registration and insurance, correct? Here is everything. I slid my folder across his desk. Marcus spent 20 minutes reviewing the documents, occasionally making notes on a legal pad. Finally, he looked up. You have a solid case, Quentin. The HOA is clearly misapplying their own rules. A neighborhood electric vehicle is not a recreational vehicle under Arizona law. They cannot arbitrarily redefine legal terms to suit their preferences. So what do I do? First, attend the board meeting. Give them a chance to correct their mistake. If they refuse, we file a lawsuit. Based on what I am seeing here, you could potentially recover your towing fees, legal costs, and possibly damages for harassment. How much are we talking about in legal fees? Marcus tapped his pen against the desk. If this goes to court, probably $5,000 to $10,000, assuming it does not drag on. But here is the thing. Most HOAs have insurance that covers legal disputes. Once we file, their insurance company usually pressures them to settle rather than risk a trial they will likely lose. Especially when the facts are this clear-cut. I just want to park my golf cart in my driveway without being harassed. Completely reasonable. Let me write you up a consultation summary and some talking points for the board meeting. If things go south, we will take the next step." I left Marcus's office feeling more confident. I was not just some frustrated homeowner complaining about petty rules. I had law and logic on my side. The days crawled by. I kept my golf cart in the garage and watched as other neighbors continued parking theirs in plain sight without any consequences. I counted 12 different golf carts within a 5-block radius of my house, all parked in driveways or carports. I photographed each one, noting the addresses and dates. On the Saturday before the board meeting, I was washing my truck in the driveway when a woman I had never seen before approached me. She was probably in her early 50s, with short blonde hair styled in that particular way that required significant hairspray to maintain. She wore white capri pants and a coral-colored blouse despite the fact that it was 95 degrees outside. "You must be Mr. Townsend," she said, her smile not reaching her eyes. "That is me. Can I help you? I am Brenda Carmichael, the HOA president. I thought we should chat before the board meeting next week." Here she was, the architect of my frustration, standing in my driveway like we were about to discuss the weather. I turned off the hose and dried my hands on a towel. "Sure, let us chat." Why was my golf cart towed? Brenda's smile tightened. "Mr. Townsend, we have standards in this community. When I drive through these streets, I want to see a clean, attractive neighborhood. Golf carts parked everywhere make us look like a retirement village in Florida. My golf cart is a legally registered vehicle. I have as much right to park it in my driveway as I do my truck. That is debatable. Our covenants are clear about recreational vehicles. It is not a recreational vehicle. It is a neighborhood electric vehicle under Arizona law. There is a legal distinction." Brenda waved her hand dismissively. "Legal technicalities aside, Mr. Townsend, this is about community standards. We have rules for a reason. If we let everyone park whatever they want in their driveways, property values will plummet. There are 12 other golf carts parked in driveways right now within 5 blocks of here. Why was mine the only one towed?" Her expression hardened. "Those situations are being addressed. But since you were the most recent violation, we started with you. Think of it as an example for others." "An example? You made me an example. I want reimbursement for that towing fee, and I want confirmation that I can park my golf cart in my driveway without being harassed. That is what the board meeting is for, Mr. Townsend. I suggest you attend and make your case. But I will tell you right now, the board stands behind our decision. We are not going to let our standards slip just because a few residents want to bend the rules." She walked away before I could respond, her white tennis shoes squeaking slightly on the concrete. I watched her climb into a Mercedes SUV parked at the curb and drive off. This woman was unbelievable. She had essentially admitted to targeting me specifically as a warning to others, which seemed like a terrible enforcement strategy and possibly discriminatory. I called Marcus Patel immediately and recounted the conversation. "Did you record it?" he asked. "No, it happened too fast." "Pity. But her admission that you were singled out as an example is useful. Write down everything she said while it is fresh in your memory. Exact quotes if you can remember them. This could be evidence of selective enforcement." I spent the next hour typing up detailed notes of the conversation. That evening, I could not focus on anything. I kept replaying Brenda's words in my head, her dismissive attitude, the way she acted like she was doing the neighborhood a favor by harassing me. The board meeting was held in the community clubhouse, a Spanish-style building near the neighborhood entrance. I arrived 15 minutes early and found about 30 other residents already there. The room was set up with rows of folding chairs facing a long table where the board members sat. Brenda Carmichael occupied the center seat, flanked by 4 other board members I did not recognize. I took a seat in the third row and reviewed my notes. I had prepared a 5-minute presentation, though I was not sure how much time I would be allotted. Other residents chatted quietly, some clearly there for other agenda items. At 7 o'clock sharp, Brenda called the meeting to order. She went through standard procedural items: approval of last month's minutes, financial reports, landscaping updates. I tried to pay attention but found my mind wandering. Finally, after 45 minutes of tedious discussion about pool maintenance schedules, she looked at her agenda. Next, we have an appeal from Mr. Quentin Townsend regarding a vehicle violation. Mr. Townsend, you have 5 minutes. I stood and walked to the front of the room, my folder in hand. 5 minutes was not much, but it would have to do. Thank you, Madam President. On May 14th, my golf cart was towed from my driveway. This golf cart is a 2024 Club Car Onward, registered with the Arizona Department of Transportation as a neighborhood electric vehicle. It has license plates, insurance, and meets all state requirements for operation on public roads. According to Arizona law, specifically ARS 28101, a neighborhood electric vehicle is distinct from a recreational vehicle. It is a legal motor vehicle entitled to the same parking considerations as any car or truck. I held up my registration and photos of the license plates. The HOA Covenant Section 7.4 prohibits recreational vehicles from being stored in visible locations. However, my golf cart does not fall under that category. Furthermore, there are at least 12 other golf carts currently parked in driveways throughout this community. I have photographs showing these vehicles, along with their addresses and dates. This suggests selective enforcement, which violates fair housing principles and the HOA's own governance documents. Brenda was already shaking her head before I finished. Mr. Townsend, the board has reviewed your appeal and we maintain our position. Golf carts are recreational vehicles. The fact that you obtained some kind of license plate does not change their fundamental nature. With respect, Madam President, state law disagrees with you. The Arizona Department of Transportation specifically classifies these as motor vehicles, not recreational vehicles. You cannot simply override state law with HOA policy. One of the other board members, a heavyset man with glasses, spoke up. Mr. Townsend, our covenants give us broad authority to interpret provisions in the best interest of the community. We believe golf carts are recreational in nature and therefore fall under Section 7.4. If you disagree, you are welcome to seek legal counsel. I have consulted with an attorney, actually. He agrees that the HOA is misapplying its own rules and potentially violating state law. Brenda's eyes narrowed. Is that a threat, Mr. Townsend? It is a statement of fact. I am asking this board to rescind the violation, reimburse my towing fees, and confirm in writing that I may park my street legal vehicle in my driveway. This is not an unreasonable request. Another board member, a woman with silver hair pulled back in a bun, leaned forward. Mr. Townsend, we understand your frustration, but we have to think about the entire community. If we allow golf carts in driveways, what is next? Motorcycles. Add EVs. We have to draw a line somewhere. The line is already drawn by state law, I said, trying to keep the exasperation out of my voice. Street legal vehicles can be parked on private property. Off-road recreational vehicles cannot. My golf cart is street legal. This should not be complicated. Brenda stood up, signaling that my time was over. The board will take your comments under advisement, Mr. Townsend. We will issue a written decision within 10 business days. Next agenda item. I returned to my seat, my jaw clenched. The meeting continued for another 30 minutes, but I barely heard any of it. When it finally ended, several neighbors approached me. "That was ridiculous," said a man named Tom who lived 2 streets over. "I have a golf cart too. They have not bothered me yet, but after tonight, I am worried." "They are on a crusade," added a woman named Patricia. "Brenda has been increasingly aggressive about enforcement this year. Last month she fined someone for having their trash cans visible from the street an hour after pickup time." "You should fight this," Tom said. "If they get away with it, they will just get worse." I thanked them for their support and headed home. My wife, Danielle Carter, had been visiting her parents in Oregon during all of this chaos, but she was due back tomorrow. I had been updating her by phone, but I knew she would be furious when she heard the full story. Danielle was not someone who tolerated bureaucratic nonsense. True to form, when I picked her up from the airport the next afternoon and explained everything that had happened, her eyes flashed with anger. "They towed our golf cart from our own driveway. Are you serious right now? Completely serious. And the board basically told me to pound sand last night." Danielle was 34, with dark brown hair and an intensity that made most people think twice before arguing with her. She worked as a project manager for a tech company, and her entire job involved cutting through red tape and making things happen. "So what is our next move?" she asked. "I am waiting for their written decision. If they deny the appeal, Marcus Patel says we should file a lawsuit." "Then we file a lawsuit. I am not letting some power-hungry HOA president bully us. We bought this house. We followed the law. They do not get to make up their own rules." I felt a wave of relief. Having Danielle on board made everything seem more manageable. She had a way of turning complicated problems into actionable steps. "There is more," I said. "Brenda basically admitted she singled me out as an example to other residents. She wants to crack down on golf carts in general, and I was the first target." "That is selective enforcement." "That is probably illegal." Marcus thought the same thing. Over the next week, Danielle and I strategized. She created a spreadsheet documenting every golf cart in the neighborhood, complete with photos, addresses, and dates. She filed a formal records request with the HOA, demanding copies of all enforcement actions taken in the past 2 years. She also started attending neighborhood social events, talking to other residents, and building a coalition of people who were fed up with Brenda's aggressive tactics. The written decision from the board arrived exactly 10 business days after the meeting. It was even worse than I expected. "After careful consideration of your appeal, the board has determined that your golf cart constitutes a recreational vehicle under Section 7.4 of the Community Covenants. Your violation stands. Additionally, you are hereby notified that parking any golf cart in a visible location will result in a fine of $100 per occurrence, plus towing fees. The board strongly encourages you to store your golf cart in your garage at all times. This decision is final unless overturned by a court of competent jurisdiction." That last line felt like a dare. They were essentially challenging me to sue them. "Fine," Danielle said when she read the letter. "Let us sue them." I called Marcus Patel and scheduled an appointment. 2 days later, Danielle and I sat in his office while he reviewed the board's decision. "Okay," Marcus said, looking up from the letter. "They want a fight. We will give them a fight. Here is what I recommend. We file a lawsuit in Maricopa County Superior Court seeking declaratory relief and damages. We ask the court to declare that your golf cart is not a recreational vehicle under the covenants, that the HOA violated its own procedures by towing without proper notice, and that they engaged in selective enforcement. We also seek reimbursement of your towing fees, your legal costs, and possibly punitive damages for bad faith enforcement. How long will this take? I asked. Probably 6 to 9 months to get to trial, assuming they do not settle earlier. But we can also file for a preliminary injunction to prevent them from towing your cart or fining you while the case is pending. Do it, Danielle said. All of it. Marcus smiled. I like your attitude. Let me draft the complaint. We should be able to file within a week. True to his word, Marcus filed the lawsuit on June 20, 2025. The complaint was 23 pages long and laid out our case in meticulous detail. It included photos of my golf cart, copies of the registration and insurance, excerpts from Arizona law, and photos of the 12 other golf carts that had not been targeted for enforcement. It also included my notes from the conversation with Brenda, where she admitted to making me an example. The reaction from the HOA was swift and predictable. Within 3 days, I received a letter from their attorney, a firm called Sanderson and Associates. The letter was full of legal bluster, claiming our lawsuit was frivolous and that the HOA had every right to enforce its covenants as it saw fit. They demanded we dismiss the case or face counterclaims for harassment and abuse of process. Marcus was unfazed. Standard intimidation tactics. They are trying to scare you off. Do not let it work. We did not dismiss the case. Instead, Marcus filed the motion for a preliminary injunction, and the court scheduled a hearing for July 15th. In the meantime, word spread through the neighborhood about the lawsuit. Reactions were mixed. Some neighbors were supportive, seeing it as a necessary stand against HOA overreach. Others thought I was making a big deal out of nothing, and that I should just keep my golf cart in the garage to maintain peace. One evening, I found a note on my windshield. It was handwritten on lined notebook paper. Stop causing trouble for the HOA. Nobody likes a troublemaker. You are making our property values go down. Danielle wanted to report it to the police as a threat, but I convinced her it was not worth it. Still, the note bothered me. I was not causing trouble. I was defending my legal rights. Why did that make me the bad guy? The preliminary injunction hearing was held in a courtroom downtown. Judge Margaret Holloway presided, a no-nonsense woman in her early 60s with a reputation for cutting through legal nonsense. Both sides presented their arguments. Marcus explained the distinction between recreational vehicles and neighborhood electric vehicles under Arizona law. The HOA's attorney, a slick guy named Richard Sanderson, argued that the covenants gave the board broad discretion and that golf carts were inherently recreational regardless of licensing status. Judge Holloway asked pointed questions of both sides. When Sanderson tried to argue that my golf cart was basically just a toy, she cut him off. Counsel, does this vehicle have a license plate issued by the state? Yes, Your Honor, but does it have insurance? Yes, but does it meet the state's requirements for operation on public roads? Technically, yes, Your Honor, but the HOA covenants. I have read the covenants, Counsel. Section 7.4 refers to recreational vehicles. Under Arizona law, is Mr. Townsend's golf cart classified as a recreational vehicle? Sanderson hesitated. The state classifies it as a neighborhood electric vehicle, Your Honor, which is not a recreational vehicle, correct? The statute does not use that exact language, Your Honor, but, Counsel, answer the question. Is a neighborhood electric vehicle a recreational vehicle under Arizona law? No, Your Honor. Thank you. Judge Holloway turned to Marcus. Counsel, what are you seeking in this injunction? Your Honor, we ask the court to enjoin the HOA from towing Mr. Townsend's vehicle or imposing fines while this case is pending. The HOA has threatened continued enforcement action, despite the fact that my client's vehicle is legally licensed and registered. Without an injunction, my client faces ongoing harassment and financial harm. Judge Holloway nodded. I am inclined to grant the injunction. The plaintiff has demonstrated a likelihood of success on the merits. The distinction between recreational vehicles and street-legal electric vehicles is clear in state law. The HOA cannot simply redefine legal terms to suit its preferences. I am ordering that the defendants are prohibited from towing the plaintiff's golf cart or imposing fines related to its parking pending resolution of this case. My written order will be issued by the end of the week. I felt like cheering. Danielle squeezed my hand. Marcus maintained his professional composure, but I could see satisfaction in his eyes. As we left the courtroom, Richard Sanderson approached us in the hallway. Your client should consider settling this before it goes further. Legal fees add up fast. Your client should consider admitting they are wrong before a jury makes that determination for them, Marcus replied coolly. Over the next few months, the case proceeded through discovery. Marcus subpoenaed HOA records, including all enforcement actions taken over the past 3 years. What we discovered was shocking. The HOA had issued hundreds of violations, but the enforcement was wildly inconsistent. Some residents received multiple warnings before any action was taken. Others, like me, faced immediate towing or fines. The pattern suggested that Brenda and the board played favorites, going easy on friends while cracking down hard on anyone they did not like or did not know well. We also deposed Brenda Carmichael. The deposition took place in Marcus's conference room and lasted nearly 4 hours. Brenda was defensive from the start, insisting that every decision she made was in the community's best interest. Why was Mr. Townsend's golf cart towed without any prior warning? Marcus asked. Because the violation was obvious, Brenda replied. We do not need to warn people about things that are clearly against the rules. But you admit that other golf carts were parked in driveways at the same time. I was not aware of those at the time. Marcus slid a photo across the table. This is a golf cart parked 3 houses down from Mr. Townsend, photographed the same day his cart was towed. You did not notice this one. Brenda glanced at the photo. I must have missed it. And this one, Marcus showed another photo. And this one and this one. You missed all 12 of these golf carts that were visible from the main road. I cannot monitor every single property every single day. But you noticed Mr. Townsend's cart immediately and had it towed within hours. It was brought to my attention by another resident. Which resident? I do not recall. The deposition continued like that, with Brenda deflecting and evading, but her credibility was crumbling. Marcus had her trapped in contradictions, and the court reporter captured every word. We also deposed the tow truck driver who had removed my cart. He testified that Brenda had personally called him and demanded immediate service, insisting it was an emergency. She had authorized him to enter my property without my permission and had agreed to pay his fee directly if I refused. Did she mention anything about warnings or prior notice? Marcus asked. No, she just said to get the cart out of there as soon as possible. She seemed really worked up about it. Worked up how? Like angry. She kept saying something about making an example and sending a message. That testimony was gold. It corroborated my account of Brenda, admitting she had targeted me specifically. As the trial date approached, the HOA's insurance company finally got involved. They sent their own lawyer to review the case, and that lawyer apparently told Sanderson that they were going to lose badly if this went to a jury. Selective enforcement, lack of due process, misinterpretation of state law. It was a disaster waiting to happen. In early November, Marcus received a settlement offer. The HOA would pay my towing fees, reimburse my legal costs up to that point, and formally amend their interpretation of Section 7.4 to exclude street-legal neighborhood electric vehicles from the definition of recreational vehicles. In exchange, I would dismiss the lawsuit and release them from any further claims. "What do you think?" I asked Marcus. "It is not a bad offer. You get your money back, you win on the principle, and you avoid the stress of a trial. But you do not get punitive damages, and Brenda does not face any real consequences." Danielle shook her head. "I want to go to trial. They need to be held accountable." Marcus leaned back in his chair. "I understand the sentiment, Danielle, but trials are unpredictable. We have a strong case, but you never know what a jury will do. And even if we win big, they will appeal, which means more time and more money. This settlement gets you closure." I thought about it for a long moment. The past 6 months had been exhausting. The stress, the conflict with neighbors, the constant battle with the HOA, it had taken a toll. On the other hand, settling felt like letting Brenda off the hook. "Can we negotiate?" I asked. "Always. What do you want?" "I want a formal apology from the board, in writing and posted on the community website. I want Brenda to personally sign it, and I want them to pay an additional $5,000 to cover the time and aggravation this has caused." Marcus grinned. "Let me see what I can do." He came back 3 days later with a revised settlement. The HOA agreed to everything except the additional $5,000. They would pay my full legal costs, which had reached about $8,000 at that point, plus the towing fee and an additional $2,000 for my trouble. Brenda would sign a formal apology that would be posted on the community website and sent to every resident. "Take it," Danielle said. "The apology is what matters. She has to publicly admit she was wrong." I agreed. We signed the settlement on November 18, 2025. The written apology was posted 3 days later. "On behalf of the Saguaro Springs HOA Board of Directors, I wish to apologize to Mr. Quentin Townsend for the mishandling of his vehicle violation case. After thorough legal review, we acknowledge that Mr. Townsend's golf cart is properly registered as a neighborhood electric vehicle under Arizona law and does not fall under our covenant restrictions on recreational vehicles. The towing of his vehicle was inappropriate and not in accordance with our own procedures. We have revised our interpretation of Section 7.4 to clarify that street-legal neighborhood electric vehicles are permitted to be parked in driveways. We apologize for any inconvenience and stress this matter caused Mr. Townsend and his family. Sincerely, Brenda Carmichael, HOA President." It was not the most heartfelt apology I had ever read, but it was public and it was official. Several neighbors reached out to congratulate me. Tom, who had worried about his own golf cart, sent me a bottle of scotch with a note that said, "Thanks for fighting the good fight." Even better, at the next HOA election in January 2026, Brenda did not run for re-election. Rumor had it that the insurance company had pressured her to step down after the settlement. A new president was elected, a reasonable guy named Stephen, who actually listened to residents and did not treat the position like a personal fiefdom. The new board also implemented changes to the enforcement procedures, requiring written warnings before any towing or fines, and establishing an appeals process that did not require waiting a month for a board meeting. It was not perfect, but it was better. On a warm Saturday morning in late January, I was washing my golf cart in the driveway when Stephen walked by with his dog. "Nice cart," he said with a genuine smile. "Thanks. No plans to tow it, I hope," he laughed. "Not a chance. Actually, I am thinking about getting one myself. They are really practical around here. Let me know if you want any advice on models. I have done way too much research on these things. Will do. And hey, I appreciate what you did last year. The old board needed a reality check. Sometimes it takes someone willing to stand up to make things better. After he walked on, I stood there for a moment, hose in hand, looking at my perfectly legal, properly registered golf cart sitting in my perfectly legal driveway. It had been a long fight, but it had been worth it. Not just for me, but for every resident who deserved to be treated fairly and not subjected to the whims of a power-hungry board president. Danielle came out with 2 cups of coffee and handed me one. Feeling triumphant, a little, mostly just relieved it is over. Well, you earned it. Not everyone would have fought that hard over a golf cart. It was never really about the golf cart, though, was it? It was about the principle, about not letting people abuse their authority just because they can. She clinked her coffee cup against mine, spoken like a true rebel. We stood there in the morning sun, drinking coffee and enjoying the peace. The neighborhood was quiet except for the distant sound of someone mowing their lawn. A golf cart drove past, the driver waving cheerfully. Another cart was parked 2 houses down, sitting in the driveway without a care in the world. Life in Saguaro Springs had returned to normal. The covenants were still there, the HOA still existed, but now there was a system of checks and balances. Residents knew they had rights. The board knew they could not just make up rules as they went along. And I had my golf cart back where it belonged. Looking back, the whole situation seemed almost absurd. 6 months of legal battles, thousands of dollars in fees, hours of stress and frustration, all because one person decided that golf carts offended her aesthetic sensibilities. But that was the nature of HOA disputes. They started small and escalated fast, because they were never really about the stated issue. They were about control, about power, about people who wanted to impose their vision on everyone around them. I had learned a lot through the process. I learned that most people do not push back against HOA overreach because it is easier to just comply, even when the rules are wrong. I learned that HOA boards often count on that compliance, that they expect residents to cave rather than fight. And I learned that sometimes, just sometimes, standing up for yourself could actually change things for the better. The legal system had worked the way it was supposed to. Judge Holloway had looked at the facts, applied the law, and made a fair decision. The insurance company had recognized a losing case and pushed for settlement. And in the end, justice had been served in the most mundane, bureaucratic way possible through paperwork, negotiations, and a public apology posted on a community website. It was not dramatic. There was no explosive courtroom showdown where I delivered a devastating closing argument. There was no moment where Brenda broke down and admitted she had been wrong all along. It was just the slow, grinding machinery of the legal system doing its job, step by tedious step, until the right outcome emerged. But that was fine with me. I did not need drama. I just needed to park my golf cart in my driveway. Over the following weeks, I noticed more golf carts appearing throughout the neighborhood. Word had spread that they were officially allowed, and several residents who had been keeping theirs in garages started parking them outside. The community actually did start to look a bit like a retirement village in Florida, but in a charming way. People used their carts to visit neighbors, to run errands, to cruise around on pleasant evenings. It became part of the neighborhood's character. One afternoon, I was heading to the community pool in my golf cart when I passed Brenda's house. She was in her front yard, pruning roses. We made eye contact for a brief moment. She did not wave, and neither did I. There was nothing to say. The conflict was over, and we would simply coexist as distant neighbors who had once been adversaries. I wondered sometimes if she understood why I had fought so hard. Did she see it as a personal attack, or did she recognize it as a necessary correction to her overreach? I would probably never know. People like Brenda rarely engaged in that kind of self-reflection. They moved on to the next thing, the next project, the next cause that needed their attention and control. But that was her problem, not mine. I had my victory, small as it might seem to an outside observer. My golf cart sat in my driveway, legal and unmolested. My property rights had been affirmed, and the HOA had learned that it could not simply ignore state law or its own procedures without consequences. Danielle and I celebrated our one-year anniversary in Saguaro Springs in March. The neighborhood had grown on us despite the HOA drama. We had made friends, found our favorite local restaurants, and established routines. The house itself was perfect for us, the right size, the right location, the right price. We had no plans to move. "Think you will ever join the HOA board?" Danielle asked one evening over dinner. I nearly choked on my wine. "Absolutely not. I have had enough HOA involvement to last a lifetime." "I do not know. You might be good at it. You clearly care about doing things the right way." Caring about doing things the right way is exactly why I would never join. I would spend all my time arguing with people who want to enforce rules about lawn heights and mailbox colors. No, thank you. She laughed. "Fair enough, but someone needs to keep them honest. That is what lawsuits are for." We finished dinner and took a walk around the neighborhood. The sun was setting, painting the desert sky in shades of orange and pink. Golf carts buzzed along the streets, their occupants enjoying the pleasant weather. Kids played in yards, dogs barked in the distance, and somewhere a radio played classic rock. It was a normal evening in a normal neighborhood, and that was exactly what I had wanted when we moved here. Not drama, not conflict, not legal battles. Just a place to live peacefully, park my vehicles on my own property, and enjoy life. The fact that I had to sue my HOA to achieve that normalcy was unfortunate but ultimately worth it. I had stood up for myself, defended my rights, and won. Not everyone could say that. Most people who tangled with their HOA either gave up or lost. I had been lucky to have the resources, the temperament, and the legal support to see it through. As we walked past the community clubhouse where the board meetings were held, I thought about that night in June when Brenda had dismissed my appeal. I remembered the frustration, the anger, the sense of injustice. And I remembered deciding in that moment that I would not back down, that I would fight this as far as it needed to go. It had been the right decision. Not just for me, but for everyone who came after. The next resident who bought a neighborhood electric vehicle would not face the same harassment I had. The next person who ran afoul of the HOA's arbitrary enforcement would have procedures to protect them. The next board president would think twice before abusing their authority. Change happened slowly in places like this, but it did happen. One lawsuit at a time, one precedent at a time, one victory at a time. My case would be filed away in some lawyer's office, cited occasionally when similar disputes arose, forgotten by most people but serving as a small bulwark against future injustice. That was enough. I did not need statues or parades or public recognition. I just needed to know that I had made things slightly better, that the next person would have an easier time because I had fought the hard fight first. We returned home as darkness settled over the desert. The lights were on in neighbors' houses, casting warm glows across manicured lawns. My golf cart sat in the driveway, exactly where it belonged, its license plate gleaming under the porch light. I walked over and patted the roof of the cart, a small gesture of affection for the vehicle that had caused so much trouble and ultimately brought so much satisfaction. It was just a golf cart, just a battery-powered vehicle with a top speed of 25 miles per hour. But it had become a symbol of something larger, of rights defended, of bullies confronted, of justice served. Tomorrow I would drive it to the coffee shop, like I did most mornings. I would wave to neighbors along the way, park in the designated spot, and order my usual medium roast with room for cream. Life would go on in its pleasant, predictable rhythm, unmarred by legal battles or HOA drama. And that, in the end, was the greatest victory of all. Not the settlement check or the apology or even the vindication of being proven right. It was simply the return to normalcy, the ability to live my life without harassment or interference, the peace that came from knowing my rights were secure. As I locked up the golf cart and headed inside, I glanced back one more time at the driveway. Everything was in its proper place. Everything was as it should be. And for the first time in months, I felt completely at peace with my decision to stand and fight. The legal documents from the case sat in a folder in my home office, a thick stack of papers that represented 6 months of effort, thousands of dollars in fees, and countless hours of stress. I would keep that folder forever, not as a trophy but as a reminder. A reminder that sometimes the right thing to do was also the hard thing, that principles mattered more than convenience, that justice, however slow and bureaucratic, was still worth pursuing. My phone buzzed with a text from Marcus Patel. Saw another golf cart in your neighborhood today. You started a trend. Hope all is well, I texted back. All is very well, thanks again for everything. Anytime. Let me know if the HOA gives you any more trouble. Will do, but I think they have learned their lesson. I hoped that was true. I hoped Brenda and the board, and every future board member would remember the Townsend case, as it had been informally dubbed around the management office. I hoped they would think twice before towing vehicles or imposing fines without proper notice. I hoped they would check state law before making pronouncements about what was and was not allowed. But if they did not, well, at least they knew now that some residents would fight back, that some people valued their rights more than a quiet life, that pushing too hard could result in expensive lawsuits and public embarrassment. The golf cart incident had taught me something important about HOAs and about life in general. Power, even small amounts of power over small things, could corrupt if left unchecked. People who volunteered for HOA boards often did so with good intentions, wanting to maintain property values and keep neighborhoods pleasant. But somewhere along the way, some of them forgot they were servants of the community, not rulers of it. They started to believe their aesthetic preferences were more important than residents' legal rights. They started to see their neighbors as subjects to be controlled rather than equals to be respected. That was when problems arose. That was when lawsuits became necessary. Not because residents were litigious or difficult, but because sometimes the legal system was the only check on petty tyranny. I was grateful to live in a country where those checks existed, where a homeowner could challenge an HOA in court and actually win. Not every place afforded such protections. Not every legal system was so accessible or fair. Despite all its flaws and frustrations, the American legal system had delivered justice in my case. It had taken time and money and effort, but it had worked. Danielle came into the home office and saw me looking at the legal folder, still thinking about it, just reflecting. It has been quite a year. Next year will be better. Less drama, more normal life. I will drink to that. We went to the kitchen, and I opened a bottle of champagne we had been saving for a special occasion. This seemed like the right moment not to celebrate the lawsuit itself, but to celebrate its ending, to mark the transition from conflict back to peace. We clinked glasses on the back patio, under a sky full of stars, with the distant lights of Scottsdale glowing on the horizon. The desert air was cool and clean, carrying the faint scent of creosote and sage. Somewhere in the neighborhood, a golf cart hummed along, its motor barely audible over the evening breeze. "To standing up for what is right," Danielle said. "Even when it is really annoying to do so," I added. We drank, and the champagne was sweet and crisp and perfect. The kind of perfect that comes from knowing you have earned it, that you have been through something difficult and emerged intact on the other side. The golf cart case was over. Saguaro Springs HOA had learned its lesson. Life was returning to normal. And my street-legal, properly registered, fully insured golf cart sat peacefully in my driveway, exactly where it belonged. Sometimes, justice really did prevail. Sometimes, the little guy really did win against the bureaucracy. Sometimes, standing up for yourself actually made a difference. This was one of those times, and I would never forget it.